My name is Teresa Callahan. I'm 39 years old, and I need to tell you about the morning I walked out of a monastery in rural Vermont with a single duffel bag, $40 in cash, and no understanding of what I was about to find out about my own family. I had been inside for 8 years. 8 years of communal prayer, of silence, of the particular kind of time that moves differently when your days are structured around liturgy rather than calendars. 8 years during which the world outside continued without me: elections, deaths, births, financial markets, the ordinary accumulation of events that constitute a life lived in ordinary time. And 8 years during which my family, it turned out, had been doing something I would not discover until I sat down with a probate attorney 14 months after my return and understood, for the first time, what the documents in front of me actually meant. I need to go back to the beginning, because the beginning matters more than you might expect. My father, Daniel Callahan, built a modest real estate business in western Massachusetts over 40 years. Nothing spectacular: residential sales, some commercial property management, a small portfolio of rental properties he had acquired slowly and deliberately over the course of a career. By the time he was diagnosed with early Parkinson's disease, he had accumulated assets. $8 million, which was not generational wealth by any modern standard, but was, for a man who had started with nothing, the evidence of a lifetime of careful work. He had 3 children: my brother Patrick, who had gone into the business with him; my sister Donna, who had married well and moved to Phoenix; and me, the youngest, the one who had always been the odd one out, the one who had spent her 20s in a process of religious discernment that had confused and eventually frustrated everyone around her, and who had, at 31, made the decision to enter a contemplative religious community in Vermont. My father did not fully understand my decision. He was a practicing Catholic, but a practical one, the kind of man who went to Mass on Sunday and found God in the details of a well-maintained property and the handshake of a kept promise. The idea of his daughter choosing a life of prayer over a life of ordinary participation was not something his framework had prepared him for. But he accepted it. He came to visit me twice in the first year, once alone and once with my mother. He sat across from me in the parlor of the monastery, the designated visiting space, with a grill between us in the traditional style, and he asked careful questions about whether I was well and whether I was certain, and I told him yes to both. The visits became less frequent as his Parkinson's progressed. By year 3, I was receiving his letters instead, written in the increasingly irregular handwriting of a man whose hands were betraying him. By year 5, the letters were dictated to Patrick, my father's voice filtered through my brother's handwriting. I want to note something about those letters because it becomes relevant later. They never mentioned financial matters. Not once. My father had always kept business and family in careful separate compartments, and his letters to me were entirely personal, about his health, about the weather, about memories of my childhood, about his faith, which had deepened as his body weakened. There was no mention of his will, no mention of the business, no mention of any financial arrangements. I understood this, at the time, as his way of protecting me from concerns I couldn't act on from inside the monastery. I did not understand it as anything else. I left the monastery in March after 8 years. The decision was entirely my own, reached slowly and without drama, a deepening sense that my vocation was not in the contemplative life, but in some form of active service I hadn't yet identified, and a recognition that staying out of loyalty to a commitment I had genuinely outgrown would not serve God or the community I had been part of. The prioress was gracious. The departure was peaceful. I left with her blessing and a duffel bag and the $40 that represented the community's standard provision for departing members. I moved into a small apartment in Springfield, Massachusetts, subsidized by a transitional assistance program for women leaving religious life. I got a part-time job at a nonprofit. I began the slow, disorienting process of re-entering a world that had continued without me for 8 years, relearning how to use a smartphone, how to navigate social media, how to think about money, how to make ordinary decisions without the framework of communal discernment. My parents were both alive when I left. My father's Parkinson's had advanced significantly. He was in a memory care facility by then, his cognitive function substantially diminished. My mother, Eileen, was living with Patrick and his family in the house I had grown up in, which Patrick had purchased from my parents 4 years earlier at what I would later learn was a price considerably below market value. That detail, the below-market sale, was the first thing the probate attorney flagged when I finally sat down with her. Her name was Margaret Alcott. I had found her through a legal aid organization that worked with women transitioning out of religious life, one of several organizations that existed specifically because the financial and legal situation of women leaving convents was, it turned out, a recognized area of vulnerability. Women who entered religious communities often signed over legal and financial autonomy. Women who left often discovered that their families had made decisions in their absence that were difficult or impossible to reverse. I had not signed over financial autonomy when I entered my community. The particular congregation I joined was not one that required formal vows of poverty in the juridical sense that would affect external legal relationships. I had remained, throughout my 8 years, a legal adult with full capacity under civil law. What my family had apparently concluded during those 8 years was that my religious life constituted a kind of practical incapacity, that my physical and intellectual removal from family affairs, combined with my stated commitment to a life of poverty and prayer, amounted to something close to an inability to exercise my rights as a beneficiary. They had not tested this conclusion legally. They had simply acted on it. Margaret walked me through what she had found when I brought her the documents I had gathered. My father's current medical records, the property records for the family home, what financial records I had been able to obtain, and the copy of my father's most recent will that Patrick had provided to me when I asked, almost casually, about the family finances during one of my first visits home. The will had been revised 4 years earlier, when my father was already showing significant cognitive decline, and when, as his medical records confirmed, he had been assessed as having moderate dementia. The revision had removed me from the distribution of the real estate portfolio. The revision had reduced my share of the liquid assets from 1/3 to a specific dollar amount of $15,000, a flat sum designated as acknowledgment of my chosen path of religious. The revision had been executed by a notary I didn't know, witnessed by 2 individuals I had never met, and drafted by an attorney whose office, Margaret noted, shared a building with Patrick's real estate office. I sat across from Margaret and read the document twice and then put it down. My father had moderate dementia when he signed this, I said. According to the medical records you've provided, yes, she said. His assessment 4 months before the revision identified moderate cognitive impairment with particular difficulty retaining new information and vulnerability to suggestion. And the attorney who drafted it worked in Patrick's building, in a different office, but yes. I asked her what my options were. She told me that challenging a will on the basis of lack of testamentary capacity and undue influence was a well-established area of probate law, but that it required evidence, medical documentation of the testator's cognitive state at the time of signing, evidence of the relationship between the drafting attorney and the beneficiary who stood to gain, and ideally testimony from individuals who had witnessed my father's condition and decision-making during the relevant period. She also told me something I had not considered. She said that my 8 years of absence from family affairs, while it did not legally diminish my capacity as a beneficiary, had created a practical information vacuum that my family had apparently filled without my knowledge or input. She said this was common in situations involving long-term religious life, military deployment, incarceration, or any other circumstance that removed a family member from ordinary participation. She said that the solution, in most cases, was documentation, establishing what had happened, when, and in whose interest. We had the medical records. We had the property transaction records, which showed that Patrick had purchased the family home at a price approximately 30% below the assessed value at the time. We had the will revision and its timing. And we had something I had not initially understood the significance of, a series of letters my father had sent me during years 3 through 5 of my time in the monastery, dictated to Patrick and written in Patrick's handwriting, which contained no mention of any financial changes, despite the fact that significant financial changes were occurring during exactly that period. Margaret flagged this as potentially significant. If my father had been of sound mind and genuinely wished to revise his estate plans to reduce my share, it was reasonable to expect that he would have communicated this to me, or at minimum, that his letters during the relevant period would not have been filtered through the person who stood to benefit most from my reduced share. The letters, dictated through Patrick, had maintained a careful silence on every financial matter. I filed a challenge to the will 6 months after my meeting with Margaret. What followed was 14 months of litigation that I will not describe in full detail because the full detail would require its own telling. What I will describe is the shape of it, the depositions, the expert testimony about my father's cognitive state, the financial records subpoenaed from Patrick's business accounts, the testimony of the memory care facility staff who had observed my father during the period surrounding the will revision. The staff testimony was the most significant piece. 3 nurses and a social worker from my father's facility provided depositions describing my father's condition during the relevant period. Their accounts were consistent. He had been pleasant and cooperative, he had recognized family members reliably, but he had demonstrated significant difficulty with complex decisions, was easily redirected when confused, and had on multiple occasions expressed contradictory intentions within the same conversation, saying one thing and then, minutes later, saying something entirely different with equal certainty. One nurse described a specific incident she had recorded in her care notes. Patrick had visited my father approximately 3 weeks before the will revision, and my father had afterward told 2 different staff members 2 different accounts of what they had discussed, one of which included a statement that he was taking care of Teresa, and one of which included a statement that Teresa had chosen her path and didn't need the same things the others did. The care note was dated. The contradictions were documented. The attorney who had drafted the revision, a man named Gerald Foote, was deposed and acknowledged that he had not independently assessed my father's cognitive capacity before accepting the engagement. He acknowledged that he had been referred to the matter by Patrick. He acknowledged that the revision had been executed at my father's facility rather than at his office, which he described as a courtesy accommodation for a client with mobility limitations, but which Margaret characterized as a choice that limited the number of independent witnesses to the signing process. Foote was not a bad attorney. He was an attorney who had not asked the questions he should have asked, and whose failure to ask them had served the interests of the person who had referred him the work. The case settled before trial. Patrick agreed to a restructured estate distribution that restored my 1/3 share of the real estate portfolio at current market valuation, which by the time the settlement was reached had appreciated significantly from the time of the will revision. He agreed to a payment representing the difference between the price he had paid for the family home and its assessed market value at the time of purchase. He agreed to a structured buyout of my share of the business interests over a 5-year period. My mother was not a party to the litigation. She had known, she told me in a conversation that was one of the most painful I have ever had, that the will had been revised. She had not known the specifics of how it had been revised or what my father's cognitive state had been at the time. She said Patrick had told her my father had wanted to make the change, that he had been clear about it, that it reflected his genuine wishes. I believe her when she says she didn't know the full picture. I also believe that the full picture was something she had not looked at too closely, because looking at it would have required her to see something about her son that she was not prepared to see. My father died 11 months after the settlement. He did not know about the litigation. He had been, by that point, past the stage where he could have understood it. I visited him at the facility in the months before his death and sat with him in the sunroom and held his hand, and we talked about things he could still reach, memories from decades ago, the smell of cut grass, a dog he'd had as a boy. He called me Teresa every time. He always knew who I was. I think about that sometimes. Whatever had happened in a room with Patrick and a document he couldn't fully evaluate, he always knew who I was. I am 39 years old. I have a settlement that took 14 months and more of myself than I expected to give. I have a brother I do not speak to. I have a mother I speak to carefully, in the way you speak to someone you love and no longer entirely trust. I have a faith that has survived both the monastery and the litigation, which I did not know, going into either, that it would be required to do. And I have learned something that I carry with me into every conversation I have about what I did with 8 years of my life. People sometimes ask me if I regret the monastery. If I wish I had stayed in the world, been present for my father's decline, been there to see what was happening before it had already happened. I tell them the truth. I don't regret it. I regret that my absence was used as a tool by someone who understood that person who cannot see what is happening cannot. That is not a reason to wish I had chosen differently. It is a reason to make sure that the people who used my absence that way understood, eventually, that absence is not the same as consent. The settlement said they understood. I have to believe that is enough. There is a part of this story I have not yet told, something that happened during the 14 months of litigation that changed my understanding of what I was actually fighting for. About 4 months into the process, Margaret received a call from an attorney she knew in a different state, a woman who worked with a non-profit organization supporting women transitioning out of religious life. The attorney had heard about my case through professional channels and wanted to know if I would be willing to speak with another woman who was going through something similar. I said yes. Her name was Patricia, and she had spent 11 years in a different congregation in a different part of the country before leaving, also in her late 30s, also through a peaceful and deliberate discernment process. Her situation was not identical to mine. Her family was smaller, the assets more modest, but the structure of what had happened to her was recognizable in every essential detail. Her brother had managed her parents' finances during her absence. Her share of the family home had been quietly reduced through a series of legal instruments. A transfer, a trust restructuring that had been executed while she was in religious life and that she had not been informed of. When she returned, she found herself listed as a beneficiary of a trust that had been restructured to give her brother primary control and distribution authority, with her share represented as a modest annual distribution rather than any direct ownership interest. Patricia had been out for 3 years before she found an attorney who understood what had happened. By then, some of the legal windows for challenging the trust had narrowed. What struck me most about our conversation was not the similarities in our situations, though they were striking. It was something Patricia said near the end of the call, almost as an aside. She said, "People assume that women in religious life are protected from this kind of thing because they've renounced material interests. They think the poverty and the prayer make you untouchable by financial manipulation. What they don't understand is that the renunciation is the vulnerability. It's the thing that makes your family feel entitled to make decisions without you." I sat with that for a long time. She was right. The assumption that a woman who had chosen religious life didn't care about inheritance, didn't need the same protections as a woman living in the world, didn't require consultation or transparency because her path had already answered those questions for her. That assumption was exactly what had made Patrick's actions feel, to him, justified. He had not needed to construct an elaborate rationale. The rationale had been handed to him by my own life choices. I found, through Margaret and through the nonprofit Patricia had connected me with, that this pattern was not rare. Women leaving religious life, particularly after extended periods, frequently discovered financial arrangements made in their absence that assumed their religious commitment constituted a permanent answer to all future material questions. Families who had not acted maliciously in any other area of their lives had made these decisions not out of greed, but out of a sincere belief that the woman in question had, by her own choice, stepped outside the domain of normal family financial obligation. The sincerity of the belief did not make its consequences any less real. I shared this with Patrick once, during one of the depositions. Not as an accusation, but as a genuine question. Did he believe, when he helped arrange the will revision, that he was doing something wrong? He was quiet for a long moment. Then he said, through his attorney, he had believed he was organizing things in a way that reflected reality, that I had chosen a life of poverty, that money was not something I had indicated I valued or needed. I asked him, through Margaret, whether he had considered asking me. The deposition record shows a pause of approximately 8 seconds before his attorney instructed him not to answer. 8 seconds is a long time to sit with a question you don't want to answer. I think about those 8 seconds often. What I also think about, and what I want to say here because I think it matters, is the question of what the monastery actually gave me that turned out to be relevant to everything that followed. 8 years of contemplative life teaches you something about patience that is different from the patience most people develop. It is not the patience of waiting for something to arrive. It is the patience of being present to what is, without demanding that it be other than it is. You learn to stay in a difficult space without resolving it prematurely, to sit with uncertainty without collapsing it into the nearest available conclusion. That quality, which I had developed in a context that had nothing to do with litigation or financial disputes, turned out to be exactly what the 14 months required. There were moments during the process when Patrick's attorneys made offers that were designed to feel like resolution, but that would have left significant value on the table. There were moments when I was exhausted enough that accepting less than was owed felt easier than continuing. There were depositions that required me to revisit my father's decline in clinical detail, to hear medical professionals describe, in the language of assessment scales and cognitive metrics, the man who had sat across from me in a monastery parlor and asked careful questions about whether I was certain. Every time, I came back to what I had learned in 8 years of communal prayer. Stay present, stay honest, don't resolve the tension until the tension is actually ready to resolve. The settlement was not everything I could have received if we had gone to trial. Margaret was clear about that. A trial carried risks, and the settlement she negotiated was, in her professional judgment, a fair outcome given the evidentiary record and the unpredictability of jury responses to a case involving family relationships and end-of-life decision-making. I accepted it, not because it was perfect, but because it was just, and because just was what I had been looking for. My father left me 45 years of a father's love that no will revision could touch. He left me a memory of a man in a sunroom who always knew who I was. He left me, in the inconsistency of his dictated letters, an inadvertent record of a silence that spoke more clearly than anything Patrick had intended. My faith is intact. That is the thing I was most afraid of losing during those 14 months. Not the money, not even the justice, but the capacity to remain who I had become in 8 years of deliberate attention to something larger than my own circumstances. Litigation is corrosive. It requires you to think in terms of evidence and leverage and adversarial interest, and it is difficult to maintain any other frame while you are inside it. But I found, to my own surprise, that that I could sit in a deposition and listen to my brother's attorney challenge the medical records and come back to my apartment in the evening and pray and sleep and return the next morning without having been changed into something I didn't recognize. That is perhaps the most unexpected gift of the whole experience. I am 39 years old. I have a settlement and a restored inheritance and a faith that has been tested in ways I did not anticipate. I have a brother I do not speak to, and a mother I love carefully, and a father who is buried in the western Massachusetts town where he built everything he built. I have, finally, something I did not have when I walked out of that monastery with $40 and a duffel bag, a complete picture of what I came back to and what it cost to reclaim it. Some days that picture is heavy. Most days it is simply true. And I have learned, after 8 years of silence and 14 months of the loudest kind of attention, that the truth, even the complicated, costly, family-fracturing truth, is the only foundation worth building anything on. My father knew that. He built 40 years of a business on handshakes and kept promises. I am his daughter. I kept mine too.